Morning, hello, and welcome. If you are a student curious about how privacy laws are shaping the digital economy, or a professional navigating compliance in your industry, or a business leader responsible for safeguarding user data, this series is for you. In this video series, we'll explore India's landmark Digital Personal Data Protection Act 2023, a transformative law that defines how personal data is collected, stored, used, and protected in a digital era. But we are not just scratching the surface. This is a deep dive across 8 focused parts where we break down the impact of the DPDP Act on some of India's most data driven and compliance sensitive industry, namely the BFSI sector, where consent, risk, reporting rules are redefining how banks and insurers operate. We look at IT service industry where global delivery centers must align with both Indian laws and client expectations. We'll then look at the healthcare sector where patients' rights and sensitive data demand ironclad protection. We look at the hospitality industry, wherein managing trust, identity, and personal preferences of millions of guests is paramount. We'll then look at the educational sector, where children's data is at the center of privacy enforcement. We'll then touch base on the world of marketing and sales, where consent is now the backbone of every outreach strategy. And finally, the social media industry, navigating new restrictions around profiling, tracking, and child safety. So, whether you are preparing for compliance in your organization or simply want to stay informed, this series is designed to simplify the law, contextualize the impact, and guide you through practical next steps. So, grab a cup of coffee, stay tuned, and let's together decode the DPDP Act one sector at a time. Let's now look at the DPDP Act and its impact on the social media industry, which includes platforms, content creators, advertisers, influencers, and data brokers involved in digital content dissemination and engagement. The Data Protection Act or Digital Personal Data Protection Act 2023 and its impact on social media industry. Part 8. Why social media is a high impact sector? Well, social media platform and their ecosystems rely heavily on user generated content and data driven personalization, including user profile, photos, videos, and comments. It includes behavioral data like likes, shares, watch histories, etc. It includes location and device data. It includes advertising identifiers, facials, and voice data. It includes metadata, interactions, hashtags, and more. The DPDP Act introduces a legal framework that reshapes how such data must be collected, stored, shared, and monetized, with heightened focus on consent, children's safety, profiling, and cross border transfer. From DPDP Act's perspective, what are the different roles? Well, the social media platforms are known as data fiduciaries, or it could also be a significant data fiduciary as per DPDP Act. Example: Meta, X, YouTube, Instagram, ShareChat, etc. The EdTech and analytics platform would be categorized as data processors. The influencer and content creators are data fiduciaries with limited, that is, if collecting user data directly, only if that is the case. Most large platforms are likely to be classified as significant data fiduciary due to the scale, sensitivity, and impact of the data they process. Let's now look at the key compliance requirement for social media platforms. In this, the consent required for data use, or there is a consent required for data use in personalization, profiling, or for ads. They must explain data usage in clear, accessible language. They require to prohibit profiling, tracking, and targeted advertising when it comes to children's data restriction. They must provide effective mechanism for user complaint. The user must be able to access, correct, delete their data. They must report data leaks within 72 hours. And they are only allowed to countries not blacklisted by the Indian government. What are the risks or critical risks for the industry? Well, deep user analytics without consent can trigger a violation. Under 18 users must be protected. Currently, many platforms lack these verifications. Misleading UI UX to force consent or engagement is a non compliance. Sharing user data with advertisers or APIs without users' knowledge is a violation. Advertising based revenue tied to user behavior must be privacy aligned. Let's now look at the children's data, a special focus area in DPDP Act. Platform must verify user age to apply children's data protection. No behavioral advertising, push notification, or personalized content to minors are allowed. No profiling or inference from content consumed or shared by under 18 users. Parental consent is mandatory if the children's data is collected. Let's now look at intersection with other laws and global standards. DPDP has a partial overlap with the IT rules 2021, which includes content moderation and due diligence. DPDP must align with breach notification when it comes in comparison with certain directions. The DPDP is closely aligned to user rights when compared with GDPR, EU. DPDP has strong parallel for under 13, under 18 rules as per in comparison to COPPA of USA. From a business impact perspective and area, that is opportunities perspective, it builds privacy first feature. It strengthens user trust and transparency. It offers opt-in personalization as a premium features. DPDP implementation would attract brands that seek privacy compliant ad environment. From a challenge perspective, retrofitting content consent model into existing interface is a major challenge. Managing content moderation alongside data rights would be a challenge. Complying with age gating and children protection obligation would be a major issue. Auditing influences data usage on platform and off platform, that is on and off the platform, is a major hurdle which the business or this industry would be facing. From a implementation priorities perspective, need to integrate clear opt-in flows for data tracking, profiling, and ad delivery. They need to implement stronger checks before access to features. They need to allow opt-out of target ads. They need to help blocking profiles for minors. They are required to offer dashboard for access, correction, deletion, and grievance submission. They need to reassess ad tech and API integration for consent and compliance. They are required to encrypt personal data, limit internal access, monitor for breaches, if any. They are required to track blacklisted countries, host Indian data in permitted regions only. They are required to educate on their responsibilities while using platform features. Let's look at grievance and dispute resolution. The platform must offer a 24 by 7 grievance mechanism. They are required to respond within defined SLAs and are required to escalate to the Data Protection Board of India if things are not resolved within the set timelines. From penalty perspective, any misuse of children's data could attract a maximum of 200 crore rupees penalty. A breach notification failure could attract 200 crore of penalty max. A non-compliance by a data fiduciary could attract a maximum penalty of 250 crores. If there are any false or frivolous complaint, it could attract a penalty of 10,000 rupees on the user. Now let's look at the checklist for the social media industry on covering every operational, technical, legal requirement for platforms, app developer, content moderator, ad tech partners, and influencer ecosystem. This framework helps align with DPD Act 2023 across all functional layers. Starting off with governance and accountability. Under this space, you will need to appoint a DPO, a data protection officer, from a privacy governance form of privacy governance committee, including legal, engineering, product, and marketing. You're required to classify the platform as significant data fiduciary based on number of users, volume of personal data, risk to electoral integrity or public order. You need to draft and publish a privacy governance policy which is aligned with the DPDP. Then we move on to data mapping and classification. You are required to conduct a data inventory of user generated content, metadata, login authentication details, device, location, IP data, photo, voice, and video contents. You need to map your data flow from collection to storage to processing to sharing to deletion. You are required to classify data on personal data or sensitive personal data or children's data when it is under 18. Once you address this, you move on to consent and notice management. You need to redesign onboarding flows to collect clear, unbundled consent for account creation, ad personalization, location tracking, data sharing with third parties. You need to present privacy notice that are simple and accessible, translated into Indian language, context specific. You need to provide access to consent dashboard for users to manage preferences. Once you address this, then we move to the critical part of children's data and age gating. You need to implement age verification. You are required to disable behavioral profiling for minors, targeted advertising, push notification, or engagement nudge for under 18 children. You need to obtain verifiable parental consent when required. You need to label and segregate child user profile within database. Once you address this, you move on to the next one, which is platform features and UI compliance. You need to prevent dark patterns that mislead users into consent. You need to enable opt out from suggested content algorithm, personalized feed, third party integration. You need to implement session timeout and access login for shared public devices. You are required to allow anonymous restricted use account where feasible. Once you address these aspects, you move on to the next one, which is ad tech and targeting compliance. You are required to ensure consent is obtained before running targeted ads. You are required to update contract with advertisers and ad tech partners to define roles, share audit and breach responsibility, avoid unauthorized cross-site profiling. You are required to block targeting of users who opt out or are identified as minors. You are required to review use of tracking pixels, cookies, and fingerprinting. Once you manage this, then you move to the next aspect of data minimization, retention, and deletion. You are expected only to collect data necessary for the platform functionality and user choice. You need to set retention timelines for account data, uploaded content, logs, and backups. You need to implement auto deletions for deactivated accounts, content removed by users, expired stories, and posts. You're required to provide user self service options for profile deletion, post removal, comment history control. Once you address these aspects, you move to the next section, which is data security and breach response. You need to implement encryption of user data in transit and at rest. You need to implement role based access control. You need to continuously your assessment of vulnerability. You need to maintain an incident response plan that includes 72-hour breach notification to the board, notification to affected users, root cause analysis, and documentation. You need to simulate breach drills regularly. Once you address this, you move to the next section, which is third party and plugin risk management. In this, you need to maintain a registry of all API integrations, plugins, developer apps accessing user data. You need to conduct security and privacy assessment before integration. You need to enforce data sharing contracts with ad partners, influencer tools, survey, quiz apps. Once you address this, you move to the next, which is user rights fulfillment and grievance redressal section, which is you need to provide users with the right to portal with the right portal to view the data, request corrections, request deletion, nominate a representative. You need to appoint a grievance officer available through in-app or web interface. You need to set SLAs for resolution of complaints. You need to maintain an audit log of all user requests and actions taken. Once you address this, you need to look at the cross-border transfer and localization readiness aspect, wherein you identify countries where user data is processed or stored, you track blacklisted notification by the Indian government, you review cloud hosting contracts and include data localization clauses if required, and you offer India-based hosting options for local user. Once you clear this and things in place, you move to the next section of awareness, training, and ethical practice. You train product teams on privacy by design aspect. You train marketing team on consent requirement. You train moderation team on data handling and reporting. You need to include DPDP module in vendor onboarding for influencers, ad agency, platform moderator. You need to publicly share a transparency report on data requests, breaches, and complaints. Once you clear all of these, you move to the last aspect here, which is monitoring, auditing, and reporting. You need to maintain a compliance dashboard showing number of consent revocation, pending user right request, breach incident, grievance closure rate. You need to conduct internal audit at least annually. You need to stay updated on the rules issued by the Ministry of Engineering and IT. You need to stay updated on sectoral advisories from IT Act or certain. You need to stay updated on global privacy trends, whether it is GDPR or COPPA. I hope this checklist helped you in some way to think through, to trigger off your thought as to how you can manage the requirements from DPDP Act and stay in compliance. Let's take a sector by sector look at how the DPDP Act 2023 impacts different industries. Because compliance isn't one size fit all. I have compiled a comparative table covering BFSI, IT services, healthcare, hospitality, education, marketing and sales, and the social media industry. So let's break it down. Consent management. Well, consent is the cornerstone of DPDP Act, but its implementation varies. In BFSI, consent must be tightly managed, especially for KYC, biometrics, and financial information. In healthcare, it's even more sensitive. Patients and parents' consent is absolutely critical. For marketing and social media, consent isn't just required, it defines whether your outreach is legal or violation. When it comes to children's data, this is where the act is more stringent or most stringent. Educational institutions and social media platforms are directly in the spotlight here. Under DPDP, profiling or targeting anyone under 18 is strictly restricted. And verifiable parent consent becomes non negotiable. Do note, verifiable. The organization need to have a mechanism where it can prove that the parental consent was indeed from the parent. Next, on the data rights enablement perspective, all sectors must now empower users to access, correct, or delete their data. That means banks, schools, hospitals, hotels, and even digital marketers need process and tools to honor these rights, preferably through user friendly portals. When it comes to breach notification, every sector is now bound to notify the Data Protection Board, and in most cases, the affected individual within 72 hours of discovering a breach. In healthcare, this could be patient's record. In hospitality, it could be passport scan. Or for social media, a profile leak or consent compromise could trigger serious reputational and legal consequence. When it comes to third party or vendor risk perspective, here's where the rubber meets the road. Whether you are a bank outsourcing IT, a school using a learning app, or a marketing team working with an agency, the DPDP Act expects you to own the responsibility for your vendor's privacy posture. Data processing agreements and audits are no longer optional, they are essential. When it comes to grievance redressal, the DPDP Act mandates every organizations to have a clear, accessible grievance mechanism. This might look like a chatbot, an email, or an in-app feature. And it's especially critical for social platforms, hotels, and edtech apps that serves diverse digital first users. Well, likelihood of being classified as a significant data fiduciaries. Well, lastly, we assess the SDF risk across sectors. It is high for BFSI, IT, healthcare, and social media because of the sheer volume and sensitivity of data they process. For educational and hospitality, it is medium to high, especially if you are running large networks. And for marketing, if you're handling mass personalization and cross platform tracking, the risk goes up fast. So, as you can see, while the principle of the DPDP Act remains universal, the real world implication differs greatly depending on the sectors. Some industry will need to overhaul their tech infrastructure, while others will need to fix their lead generation or outreach tactics. But for all of us, it's a journey towards being more transparent, ethical, and user centric data practice. In the next part, we'll deep dive into each sector one by one. So stay tuned and don't forget to like, share, and subscribe if you are finding this series helpful. Do note this slide we will come again and again on all the modules that we are going to discuss. So, in case you have missed out or you need to have a better context, so when we look at BFSI and IT services and all the other areas, we will refresh this slide again and the context. In conclusion, social media platform must pivot for collect and monetize to respect and engage. The DPDP Act demands accountability, transparency, and user control at every level of platform operations. The DPDP Act will fundamentally reshape how social media platforms operate in India, from content delivery to ad monetization. The future is opt in, user controlled, and trust driven. Early compliance effort will help platform retain user trust, avoid penalties, and stay globally competitive in privacy aware market. I hope this video has helped you in your planning strategy or how you can get aligned to the requirements of the DPDP Act for your industry. If this has helped you or has added value to your table, do like and subscribe. Definitely do share it with those who you think can benefit from this. The whole idea is to spread what we know and help the society as a overall. With this, I come to the end of the whole series. The first part of the series was on the overall digital Personal Data Protection Act. The rest seven were specific on sectors. So you can choose the sector that helps you. Go with the checklist. You can run with it as it is. You can modify it, customize it based on your requirement. I believe this brings value to you and your table, helps your organization improve, align, and avoid any penalties coming from this act. My best wishes to you. This is your host Savit Vittal Salian. I thank you for the time that you invested. I thank you to all the motivation that you have provided me to create this video series. Special calling out to Sanjeev, Rita, Likit Bhakti, some of my best motivators. To my mentor, Sri Ganapati, Sri Bhairava, Sri Narayana. Thanking you. Namaskar.